Hi, it's Mike DelSignore. In today's video, I want to talk about what is our philosophy at DelSignore Law. How do we handle OUI cases? What do we hope to provide you in terms of value in your case? Well, my hope is to help you make the best decision for you in your case, and that varies from person to person. For some, and for many, it's to fight the case, to win the case at trial, to avoid an OUI conviction. We have many clients who say, I need to get back on the road. So the goal there is to resolve the case as quickly as possible, get a hardship license. So on a first offense OUI, you can't drive during the refusal suspension for 6 months. So if you're going to fight the case, you need to be able to figure out a way to drive while I'm fighting the case in court. Generally, it's going to take a minimum of 4 months to get a case to trial. If you're found not guilty, there's a presumption you get your license back prior to the 6 months. In many courts, you can't get a trial prior to 6 months. So it's very hard to get back on the road right away without resolving the case. So plan B is, if you can't go any time without driving, is to resolve the case. Once you resolve an OUI with a continuance without a finding and get the 24D program, you could potentially get a hardship license, assuming you get a letter from work, you're a Massachusetts license holder. If you're not a state license holder, resolving the case quickly is not going to help you get back on the road because the RMV can't grant a hardship for an out-of-state driver. So you'll need the letter from work. If you can't get a letter from work, the RMV won't grant you a hardship license. So in that case, you might as well fight the case if you're not going to get a hardship license. But when people call me, so I talk to them about the case, I make sure we go over all of the options and try to figure out what is the best plan for you in your case. Now, what people don't understand is initially we don't get all the information about the case. So you'll be arraigned, your first court date, let's say you're arrested over the weekend, you're going to be arraigned on the case, brought to court for an arraignment. We'll get a copy of the police report, but much of the critical evidence in the case is going to take 6 weeks, it could take 2 months. We really don't know how long it's going to take. So if there's video evidence in the case, and now state police all have body camera, many of the local departments have booking videos. I would say it's unusual now to not get some video on a case. To get that evidence, it's going to take a few months, usually. It could be quicker, but it's highly unlikely. I'd say 6 weeks is probably around the average. So what we have to do is basically assess the case with the information we have, and in many cases, we'll need to wait for the additional information to fully evaluate the case and to help you make an informed decision about whether to take a plea, to fight the case, or do additional motions. Sometimes if you took a breath test, there might be a good motion to exclude the breath test from evidence based on the video. Officers need to do what's called a 15-minute observation period. Many times in the video, it shows that it was not complied with, and that can be a basis to exclude the video. So what I hope to do is help you make a great decision for yourself for your case. The other thing, if you need help with alcohol, if you need treatment, let's say this is your second or third offense, or if it's a first offense, but things have been tough. You can be not guilty in the case. This is one of the big misunderstandings that people have. You can get treatment for an alcohol problem, and it's never going to affect the case negatively. In other words, this might be your first OUI. So you can go in for treatment if you need it, and it's not going to affect the case in a negative way. In other words, no one's ever going to say you're guilty because you went for alcohol treatment. In fact, it's only going to be a positive. So I can recommend places you can go for treatment. If it's your second and third offense, you might need to do it for the court, potentially for the RMV. But even if it's just for yourself, if you're saying, hey, things haven't been good for me in my life, I want to get help, you can. We can win the case. You can be found not guilty, and you can take care of any alcohol problem, assuming you have one, and we can still win the case. So you can do both. I want to make sure that, one, you have a great outcome in the case. Two, I hope you have a great future ahead, and that this incident is basically something you're going to put behind you and move forward with your family, your career, and your life. So many former clients of mine I still talk to, keep in contact with, and I hope to be able to share my knowledge, my view of the world, and my experience as your lawyer to help you not only with the case in court, but help you with anything else I can related to the legal problem or any other issues you have in your life. So that's my goal, is help you make a great decision on the case. Usually that's get you a not guilty in court, and that's where all my training experience comes in, where I've fought these cases for 20 years. I've gone to courts throughout Massachusetts. I've cross-examined hundreds of offices, and I know what to look for. I'll go over the report with you and tell you basically what my strategy for winning your case will be. Second, if you can't go that time without driving, get you back on the road. Give you a plan to get back on the road. If it's your second offense within 10 years, you have to go through the requirements for an interlock and a hardship. So if you have questions about an OUI, feel free to call, text anytime, 781-686-5924. My passion is helping people charged with OUI cases, and I'll be glad to help you answer any questions you have, review your case, and discuss the best decision for you in your case.